Sexual harassment is recognized as a violation of human rights. Sexual harassment can happen to anyone, at anywhere, such as in schools, workplaces, public transportations, and even online. Sexual harassment can be a traumatic experience that affects a person's physical, emotional, and psychological well-being. But did you know that there is a law in the Philippines that aims to protect everyone from sexual harassment? Presenting to you the Republic Act 7877. What is Republic Act 7877? An act declaring sexual harassment unlawful in the employment, education, or training environment and for other purposes. This act, which is a consolidation of House Bill number 9425 and Senate Bill number 1632, was finally passed by the House of Representatives and the Senate on February 8, 1995, wherein, under Section 1 of this act, states that this act shall be known as the Anti-Sexual Harassment Act of 1995.
Now, let's proceed to Section 2. This section outlines the policy of the state to uphold the dignity of individuals and guarantee respect for human rights in the workplace, education, or training environment. It emphasizes the unlawful nature of all forms of sexual harassment in these settings. The state values development of human resources and aims to provide a safe and harassment-free environment for workers, students, and trainees to maximize their potential. So next, for the Section 3 of the law. It defines work, education, or training-related sexual harassment as any act of demanding, requesting, or requiring sexual favors in a work, education, or training environment by a person in authority regardless in whether the objects of such demands of request accept them or not. The perpetrator can be an employer, employee, manager, supervisor, teacher, coach, trainer, or any other person who has the power to influence or control another person in that environment.
In a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting said individual favorable compensation, term, conditions, promotions, or privileges, or the refusal to grant the sexual favor results in limited segregating or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. 2. The above act would impair the employee's rights or privileges under existing labor laws, or number 3, the above act would result in an intimidating, hostile, or offensive environment for the employee. In other words, sexual harassment occurs when an individual is subjected to unwanted sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature that affects their ability to perform their job or create a hostile work environment. These can include things like inappropriate comments, touching, or gestures, as well as more subtle forms of harassment like the use of displaying sexually suggestive pictures or objects in the workplace. Sexual harassment can also take place online or through other forms of digital communication.
In an education or training environment, sexual harassment is committed when: number 1, against one who is under the care, custody, or supervision of the offender. 2. against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. Number 3. When the sexual favor is made a condition to the giving of a passing grade or the granting of honors and scholarship or the payment of a stipend, allowance or benefits, privileges or considerations. Or number 4, when the sexual advances results in an intimidating, hostile or offensive environment for the student, trainee or apprenticeship. This means that sexual harassment in an educational or training setting can occur when someone in a position of authority, such as a teacher or supervisor, engages in inappropriate sexual behavior or makes unwanted sexual advances towards someone who is under their care or supervision. This can also happen when someone's education, training, or career opportunities are affected by their response to sexual advances or harassment. Additionally, if the behavior creates an uncomfortable or hostile environment for the individual, it is also considered sexual harassment.
And now, let's discuss about the Section 4 of this Act. This section of the law imposes upon employers or heads of work-related, educational or training environments the duty to prevent or deter acts of sexual harassment and provide procedures for the resolution, settlement, or prosecution of sexual harassment cases. To fulfill this duty, the employer or head of office is required to promulgate appropriate rules and regulations in consultation with employees or students through their duly designated representatives, prescribing the procedure for investigating sexual harassment cases and the administrative sanctions for such act. These rules and regulations must also include guidelines on proper decorum in the workplace and educational or training institutions. Furthermore, employers and heads of office are required to create a committee on decorum and investigation of sexual harassment cases. This committee shall conduct meetings with officers, employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It is also tasked to investigate alleged cases of sexual harassment. The administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful act of sexual harassment.
This passage outlines the composition of the committee that will handle and investigate cases of sexual harassment in different environments. In a work-related environment, the committee must have at least one representative from the management union, if there is one, the supervisory rank employees, and the rank and file employees. For an educational or training institution, the committee must have at least one representative from the administration, trainers, teachers, instructors, professors, coaches, students, or trainees. Moreover, the employer, head of office, educational or training institution should disseminate or post a copy of this act for everyone to read and be sanctioned.
And now let's discuss about Section 5 of this Act. Section 5. Liability of the employer, head of office, educational or training institution. This section of the law states that an employer or head of office, educational or training institution may be held liable for damages that result from act of sexual harassment committed in the workplace, education, or training environment. The liability is shared by both the individual offender and the institution. However, the institution can avoid liability if They take immediate action upon being informed of the harassment by the victim. This provision ensures that employers or heads of offices actively combat sexual harassment and create a safe and respectful working environment for all employees. In Section 6 of this Act, it states that independent action for damages. This section of the Act states that a victim of work, education, or training-related sexual harassment has the right to pursue a separate and independent legal action for damages and other relief, regardless of any other actions or procedures that may be taken under the Act. Essentially, this means that the victim has the right to seek additional legal remedies beyond those provided by the Act if they so choose.
Section 7. This section outlines the penalties for individuals who violate the provisions of the Act. If convicted, the person could face imprisonment of at least 1 month and up to 6 months, a fine of at least 10,000 pesos but not more than 20,000 pesos or both. The court has the discretion to choose the appropriate penalty. Additionally, any legal actions resulting from a violation of the Act must be taken within 3 years.
So remember, your body is not a commodity to be touched or commented on without your permission.
Speak up when you witness sexual harassment. Staying silent only perpetuates the problem.
Sexual harassment is not a joke. It's a violation of basic human rights.
That's all for the Republic Act number 7877,
Or also known as the Anti-Sexual Harassment Act of 1995. Thank you for watching. Bye!